Hello, everybody. Hello, welcome. I'm a little bit early tonight. I just wanted to come on a few minutes early because I do have the modified bond order for Mr. Floyd that came out of the Georgia case. So I thought I would go over that real quick. I do plan to go through the Texas abortion lawsuit tonight, but I thought I would just pop on a few minutes early and take you through the modified bond order that was issued in the Georgia case. So here we go. This is out of the Georgia case for Fulton County, and it's Georgia versus Harrison William Prescott Floyd. We had some problems regarding information being leaked to the media, and then he had lots to say about that on his social media, and so there was a request to revoke his bond. The revocation was actually denied, so his bond was not fully revoked, but Judge McAfee said he would put in some new requirements for his release. So that's what we have here. So, modified bond order for defendant Harrison Floyd. The above captioned matter having come before the court pursuant to the state's motion to revoke bond, the court finds the defendant is in violation of the conditions of bond previously set by the court, grants in part the state's motion, and orders that bond in this matter is modified as follows. So he did find there was a violation of his bond agreement, but did not revoke. The bond amount, number one, the amount shall remain the same as consented to by the state and defendant on August 29th. So for count one, which was the RICO Act count, $40,000, count 30, conspiracy to commit solicitation, $30,000, and count 31, influencing witnesses, which is $30,000, for a total of $100,000. Number two, the defendant shall report to pretrial supervision every 30 days and may report by telephone. Number three, the defendant shall not violate the laws of this state, the laws of any other state, and the laws of the United States of America or any other local jurisdiction. The defendant shall appear in court as directed by the court. The defendant shall have no contact with any co-defendant, witness, or any person specifically named in the indictment in this case. The defendant shall perform no act to intimidate any co-defendant in this case. The defendant shall perform no act to intimidate any witness in this case. The defendant shall perform no act to intimidate any person specifically named in the indictment in this case. The defendant shall perform no act to obstruct the administration of justice. Again, he's just clarifying the conditions of bond. So for Mr. Floyd, the defendant shall make no public statement of any kind concerning any co-defendant or witness in this case, concerning any person specifically named in the indictment. This shall include, but it's not limited to, statements in books, statements in newspapers, statements in magazines, statements on television, statements on radio, podcasts, YouTube, Rumble, or any other commercial or self-published media. The defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any co-defendant in this case except through his or her counsel. The defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any witness in this case except through his or her counsel. The defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any person specifically named in the indictment except through his or her counsel. And here's the big change, everybody. The defendant shall make no social media post of any kind on any platform, whether public or private, concerning any co-defendant or witness in this case, or concerning any person specifically named in the indictment. This shall include, but is not limited to, mentioning, example, at username, referencing, tagging, direct messaging, following or subscribing to, liking posts of another user that would violate this order if posted by the defendant, commenting on or replying to posts by another user that would violate this order if posted by the defendant, and reposting posts by another user that would violate this order if posted by the defendant. Social media posts of by any other user that would violate this order if posted by the defendant. Social media posts of any kind on any platform shall include, but it's not limited to, streaming, blog posts, Twitter, also known as X, Truth Social, Instagram, Facebook, TikTok, Parler, Gab, Telegram, and GiveSendGo. The defendant shall abide by all terms of this court's order on protective order over pretrial discovery and the attached protective order regarding all pretrial discovery in the indictment number 23 SC 188947 entered on November 16th of 2023. The defendant, within 12 hours of the entry of this order, shall delete any previously posted social media posts that violate any of the terms of this modified order, including any posts mentioned by the state in pleadings or in the November 21st, 2023 hearing on the state's motion to revoke bond. It's so ordered this 21st day of November, signed by Judge Scott McAfee. So there you go, everybody. That's the update on Mr. Floyd's bond situation. Of course, we had a bond hearing earlier, just last week, regarding whether or not to revoke his bond. His bond has not been revoked. He has been found to violate his bond, and new conditions have been set. So I just wanted to give everybody a little heads up on that before I dive into tonight's topic. So there you have it. If you're interested in pulling this document yourself, here is the case number, and you can pull up the modified bond order, and it is available online. Okay, well, welcome everybody. Good to see you all. Welcome in. Nice to be back again. So tonight, everyone, I do have for our schedule the lawsuit that has been filed against the state of Texas. This is the abortion lawsuit, which is what we are referring to it as here. So I will be going through this lawsuit with everyone tonight. So this is available online as well if you'd like to pull this yourself. This is the file number up here. It was filed in the District Court of Travis County in Texas. We have our petitioners here. This is a civil case. So we've got Zherwowski, Miller, Hall, Zargarian, Brandt, Carson, MD, on behalf of herself and her patients, and Levison, MD, MPH, on behalf of herself and her patients. So we have two doctors included as well, along with the other petitioners. They are suing the state of Texas, the Attorney General of Texas, Ken Paxton, in his official capacity as Attorney General of Texas, Texas Medical Board, and the Stephen Brent Carlton in his official capacity as Executive Director of the Texas Medical Board. So these are our defendants. These are the symbols I typically use when I'm going through any of my documents. So just to let you know, we did have a couple of other people who have joined onto this petition, I believe, since I printed this. So, but I will add those names later on. So here we go, everybody. This is a very sensitive topic. I do have comments off so that I can go through the petition in its entirety. I will do a Q&A afterwards to try to go through what the legal questions are here in the case. It's a very well-written petition regarding what's going on in Texas and the abortion law there. So I do caution, if this is a triggering topic for you, you may want to skip this live, but if you are interested in what's going on and how these are being addressed legally, I will go ahead and just dive on into the case. So welcome in, everybody. Plaintiff's original petition for declaratory judgment and application for permanent injunction. Now, one thing, before I forget, everyone, I do want to put my label here. I'll forget once I flip the page. So this is the Texas abortion lawsuit. Okay, there we go. Here we go. Oh my goodness, John, thank you. Thank you very much. All right, here we go. Make sure I'm in frame. As a direct result of Texas's abortion bans, Texas is in the midst of a healthcare crisis. Ms. Zherwowski, Miller, Hall, Zargarian, Brandt, and countless other pregnant people have been denied necessary and potentially life-saving obstetrical care because medical professionals throughout the state fear liability under Texas's abortion bans. Amanda was forced to wait until she was septic to receive abortion care, causing one of her fallopian tubes to become permanently closed. When Lauren learned one of her twins was not viable, she was forced to travel out of state for the abortion she needed to save her and her other baby's life, who is due in several weeks. Lauren received a devastating fetal diagnosis 2 weeks after Roe was overturned, and in the chaos that followed, she was forced to travel to Seattle for an abortion. Pregnant again now, Lauren fears that Texas is not safe for her or her family. Anna was forced to fly across multiple states after her water broke, risking that she would go into labor or septic shock on the journey. Ashley had to travel out of state for an abortion to save the life of one of her twins. And afterwards, fearful of documenting Ashley's abortion, her Texas physician instead described her condition as vanishing twin syndrome. Yet, with the threat of losing their medical licenses, fines of hundreds of thousands of dollars, and up to 99 years in prison lingering over their heads, it is no wonder that doctors and hospitals are turning patients away, even patients in medical emergencies like Amanda, Lauren H., Anna, and Ashley. Plaintiffs filed the original petition for declaratory judgment and application for a permanent injunction because uncertainty surrounding the meaning of the exception to Texas's abortion bans, codified as Texas Health and Safety Code sections 178.001, the exception to the trigger ban, and Texas Health and Safety Code sections 171.002, the medical emergency exception to Senate Bill 8 of 2021, collectively the emergent medical condition exception, has caused and threatened to cause irreparable injury to plaintiffs and the physician plaintiffs as patients. In support of their petition, plaintiffs respectfully show the following. So here we go. We'll go into some of the details of these different situations. Again, viewer discretion here. Introduction. Abortion bans harm the health of women and pregnant people. In September of 2021, Senate Bill 8 effectively imposed a statewide ban on abortion after approximately 6 weeks of pregnancy. Footnote number 1, consistent with standard medical practice, gestational ages as used in this petition are dated from the first day of the patient's last menstrual period, which is typically approximately 2 weeks before the estimated date of fertilization of a pregnancy. After the U.S. Supreme Court overruled Roe v. Wade in June of 2022, Texas's near-total abortion ban took effect. Texans have suffered catastrophic harms because of those bans. Pregnant people in Texas and throughout the country have suffered unnecessary physical and emotional pain and harm, including loss of their fertility. These pregnant people are not hypothetical. They are not unknown. They are real people with families, many with children already, and some of them are plaintiffs in this action. Just make sure again that I'm in frame, everybody. Local newspapers and social media abound with stories of abortion bans harming pregnant people and their families, a large number of whom live in Texas. In every person's story, the same theme emerges. First, abortion is necessary health care that is being denied under Texas's civil and criminal abortion bans. Second, abortion bans are preventing pregnant people from receiving the standard of care from their medical professionals in times of crisis. And third, pervasive fear and uncertainty throughout the medical community regarding the scope of the life and health exceptions have put patients' lives and physicians' liberty at grave risk. Abortion bans are hindering or delaying necessary obstetrical care. And contrary to their stated purpose of furthering life, the bans are exposing pregnant people to the risks of death, injury, and illness, including loss of fertility, making it less likely that every family who wants to bring children into the world will be able to do so and survive the experience. Medical professionals are now telling their patients that if they want to become pregnant, they should leave Texas. Plaintiffs represent only the tip of the iceberg. Since September of 2021, millions of people of reproductive capacity in Texas and beyond have been denied dignified treatment as equal human beings. This court need not guess at the impact that abortion bans have. Each day in states across the country, pregnant people like Amanda, Lauren M., Lauren H., Anna, and Ashley are being denied their ability to control their reproductive lives and to build their families according to their own values and beliefs. Medical professionals are being forced to forego practicing their profession and fulfilling their ethical duties to patients in the face of catastrophic risks to their liberty and livelihood. Plaintiffs' experiences illustrate that while the stated purpose of Texas's abortion bans may have been to promote healthy babies and families, the bans have done the opposite. Plaintiffs respectfully ask this court for a declaratory judgment clarifying the scope of Texas's emergent medical condition exception to its abortion bans and any and all declaratory and injunctive relief necessary to protect the health and lives of pregnant Texans with emergent medical conditions. Discovery Control Plan. Plaintiffs request that this case be conducted as a Level 3 case for the purposes of discovery, in accordance with Texas Rule of Civil Procedure 190.4. In addition, pursuant to Texas Rule of Civil Procedure 47C5, plaintiffs state that they seek non-monetary relief only. So they are not asking for any kind of monetary damages, everybody. Just keep that in mind. Parties. Number 1, the plaintiff, Miss Amanda. Amanda's 35 years old and lives in Austin, Texas. Amanda and her husband have known each other since preschool and were married in 2019. They have long wanted to have children. When they started trying for a baby, however, Amanda learned that she was not ovulating. After a year and a half of fertility treatments, which included exploratory procedures, use of multiple medications, one misdiagnosis, and treatment with the IUI, Amanda finally got pregnant for the first time. Amanda's pregnancy proceeded without incident until 17 weeks, 6 days. She was diagnosed with an incompetent cervix, weakening of the cervical tissue that causes premature dilation of the cervix. Because her pregnancy was still so many weeks before viability, she was told that her baby would not survive. And then we have footnote number 2 here. This petition describes pregnancy using medical terminology unless describing a particular patient's pregnancy, in which case, consistent with the principles of medical ethics, it adopts the terminology preferred by the individual patient. Amanda and her husband were devastated and kept asking if there was anything her doctors could do. Amanda specifically asked if she was a candidate for a cerclage, a procedure where a patient's cervix is stitched closed to prevent preterm birth. Her doctors told her that unfortunately her membranes were already prolapsing, meaning that a cerclage procedure would be too risky and in any event would not be successful. Amanda was sent home, and that night her water broke. It was Tuesday, August 23rd of 2022. Amanda returned to the emergency room that night and was diagnosed with preterm pre-labor rupture of membranes, also known as preterm premature rupture of membranes, or PPROM, because all of Amanda's amniotic fluid drained when her water broke. The emergency room kept her overnights in the hopes that she would go into labor on her own. In the morning, however, she had not gone into labor. Her baby still had cardiac activity, and her vitals were still stable, meaning she was not yet showing signs of acute infection. Amanda was told that under Texas's abortion ban, there was no other medical care the hospital could provide. At this point, absent Texas's abortion bans, a patient in Amanda's situation would have been offered an abortion or transferred to a facility that could offer the procedure. But Amanda was offered neither because the hospital was concerned that providing an abortion without signs of acute infection may not fall within the emergent medical condition exception in Texas's abortion bans. Amanda was told that delivery could take hours, days, weeks. Once Amanda heard it could take hours, she decided there was no time to travel to another state for an abortion. She looked it up, and the drive to the closest abortion provider in Albuquerque, New Mexico, would be 11 hours. The specialist at the hospital also urged Amanda to stay within a 15-minute drive of the hospital in case her health deteriorated quickly. On Wednesday morning, Amanda was sent home with instructions to monitor herself for signs of infection. Amanda spent Wednesday and Thursday at home, grieving her inevitable loss and worrying about her own health. On Thursday morning, Texas's trigger ban went into effect. On Friday morning, Amanda went for a checkup at her obstetrician's office. At her appointment, her vitals were still stable. On the drive home from her obstetrician's office, however, Amanda developed chills and started shivering, and by the time she got home, she had a temperature of 101 degrees and was not responding to her husband's questions, all signs of sepsis. Amanda's husband called the obstetrician's office, and while he was waiting for a callback, decided he could wait no longer and needed to take her to the emergency room immediately. By the time Amanda was admitted to the labor and delivery unit, her temperature was at 102 degrees and peaked at 103.2 degrees. Her medical team confirmed that she was indeed sepsis and put her on antibiotics. The hospital finally agreed she was sick enough that inducing labor would clearly not violate Texas's abortion bans. Amanda delivered her baby. Willow passed away. That night, Friday, Amanda's fever subsided, but her blood pressure and platelet levels remained abnormally low. Amanda was told that while the first infection had cleared, she had developed a secondary infection, called this an septic shock. The subsequent bout of sepsis landed her in an intensive care unit. Amanda spent 3 days in the ICU while her infection was treated. Amanda's family flew to Austin from across the country because they were worried it would be the last time they would see her. Amanda was eventually discharged and returned home, but her suffering was far from over. The infections had caused such severe scar tissue to develop in her uterus and on her fallopian tubes that it obscured X-ray imaging of her reproductive organs. She had a procedure to attempt to remove the scar tissue, and while her physicians were able to clear her uterus and one of her fallopian tubes, the other fallopian tube remains permanently closed. Amanda has been advised by her reproductive specialist that to get pregnant again, she should start IVF, which involves its own invasive procedures and uncertain success. Amanda has already begun IVF treatments. Once a pregnant person has been diagnosed with an incompetent cervix in one pregnancy, the risk is high that it will develop the same condition in future pregnancies. Amanda and her husband have been trying to have children for years, and she not only lost her first pregnancy, but because of Texas's abortion bans, she nearly lost her own life and spent days in the ICU for septic infections whose lasting impacts threaten her fertility and, at a minimum, make it more difficult, if not impossible, to get pregnant again in the future. Amanda's claims are capable of repetition, but evading review. Amanda sues on her own behalf. Next, Lauren Miller. Lauren Miller's 35 years old and lives in Dallas, Texas. Lauren first learned she was pregnant from a pharmacy test in July of 2022 and quickly realized that the first day of her last menstrual period, the date from which the pregnancy would be dated, was June 24th of 2022, the same day Roe v. Wade was overturned. Lauren M. already has a 19-month-old son, and she and her husband were excited to have another child join their family. She started keeping a pregnancy journal to document the details of her pregnancy and her emotions about her pregnancy. Laura M. scheduled her first prenatal visit for approximately 8 weeks. Before her first prenatal visit, however, Laura M.'s health took a turn for the worst. She experienced horrible nausea and vomiting and could not keep food or even water down. After 36 hours of continuous vomiting, Laura M. went to the emergency room for treatment for dehydration. At the emergency room, Laura M. had her first ultrasound and learned she was pregnant with twins. She and her husband were shocked but thrilled. At the emergency room, Laura M. was also diagnosed with hypermesis gravidarum, a severe form of persistent nausea that can last throughout pregnancy and cause significant risk for pregnant people and their babies. Laura M. began treatment for the issue but did not respond to medications and continued to struggle with nausea and vomiting as her pregnancy progressed. At Lauren M's 12-week ultrasound appointment, she learned that baby B was not growing as fast as baby A. And while that was a cause for potential concern, obtaining a diagnosis would require additional monitoring and testing. Laura M. provided a blood sample for non-invasive prenatal blood testing, which can be done between 10 and 13 weeks to screen for some fetal conditions. While Laura M. was still waiting for the NIPT results, she returned a week later for another ultrasound and learned that baby B had developed 2 cystic hygromas, fluid-filled sacs near the brain. While worrisome, Laura M.'s physician still could not yet diagnose baby B's medical condition and recommended additional testing, specifically CVS and amniocentesis, which involved a needle procedure into the placenta or amniotic fluid. Several days later, Laura M. received the results from her NIPT test, which indicated that baby B likely had trisomy 18, a condition with a very high likelihood of miscarriage or stillbirth and low survival rates beyond the first year of life. Laura M. met with a genetic counselor who struggled to give clear information regarding what this result meant for her pregnancy under Texas's new abortion bans. After receiving a referral to a maternal fetal medicine specialist who could perform CVS testing, Lauren M. scheduled the first available appointment, which was for the following day. The following day, Lauren M. visited an MFM specialist who performed a high-resolution ultrasound and attempted CVS testing. The MFM confirmed via ultrasound that baby B had multiple fetal structural abnormalities, cystic hygromas, which much of the brain should have been developing, a single artery umbilical cord, incomplete abdominal wall, abnormal heart, abnormal nuchal translucency, and told Lauren M. and her husband that baby B would likely not survive to birth. Because the ultrasound alone was so conclusive and because Lauren M.'s uterus was contracting and preventing the needle from reaching the placenta of baby B, the MFM did not ultimately complete the CVS test. The MFM told Lauren M. and her husband that before SB 8, they would have been able to offer Lauren M. a fetal reduction, an abortion of baby B, to give baby A and Lauren M. the best chance to avert a health crisis. Now all they could do was suggest that she travel out of state. Let me just make sure I'm in frame, everybody. In every interaction with their medical team in Texas, Lauren M. and her husband felt confused and frustrated and could not get direct answers. It was apparent that their doctors, nurses, and counselors were all fearful of speaking directly and openly about abortion for fear of liability under Texas's abortion bans. A few days later, after Lauren M.'s visit with the MFM, she was hospitalized again with complications from hyperemesis gravidarum. Lauren M. was vomiting so violently that she was unable to drive herself to the emergency room and had debilitating chills and severe dehydration, requiring hospitalization. If not for Texas's abortion bans, Lauren M. would have had the fetal reduction before her subsequent emergency room visit. Lauren M. and her husband remained deeply concerned about her health as well as that of baby A. They ultimately decided to travel out of state to receive a selective fetal reduction abortion procedure. They named baby B Thomas and started to say goodbye. At 15 weeks at a clinic in Colorado, Laura M. underwent the selective reduction abortion procedure, which was quick and uncomplicated, yet the procedure plus the associated travel cost thousands of dollars and required Lauren M. and her husband to be away from their son for 2 days. After the procedure, Laura M.'s hyperemesis gravidarum symptoms immediately subsided, and her pregnancy with baby A has since progressed without complications. Lauren M. lost so much weight from the hyperemesis gravidarum that she did not return to her pre-pregnancy weight until 29 weeks. Lauren M. is thankful that she had the funds and support from family, friends, and employers to allow her and her husband to travel for the health care she needed. She has friends in the medical field who helped her connect with doctors out of state. She knows that many other pregnant people have not been so fortunate. Lauren M. was overjoyed to discover she was pregnant with twins, but after suffering from extreme hyperemesis gravidarum and devastating fetal diagnosis for baby B, Texas's abortion laws made it less likely that both she and baby A would survive her pregnancy. Lauren M. is due to give birth to baby A at the end of March of 2023. Lauren M. fears for her safety as a pregnant woman in Texas. Lauren M.'s claims relate both to her current pregnancy and future pregnancies and are capable of repetition, but evading review. Lauren M. sues on her own behalf. Next, we have Lauren Hall. Lauren Hall is 28 years old and lives outside Dallas, Texas. Lauren H. and her husband were thrilled they found out that she was pregnant. At her first ultrasound around 8 weeks, everything looked great because her pregnancy was uncomplicated. Laura H. would not have another ultrasound until her anatomy scan, which was usually scheduled later than 16 weeks. In the meantime, Lauren H. started planning, telling friends and family the news, buying baby clothes and furniture, and even selected a name, Amelia. Lauren H. knew that her OBGYN was opposed to abortion, but at the time it did not seem like a big deal. 2 weeks after Roe v. Wade was overturned, however, Lauren H. went to an appointment with an MFM specialist for her 18-week anatomy scan. Lauren H. is a nurse, and when the ultrasound began, she knew immediately that something was wrong. Lauren H. was told that her baby had a condition where the baby does not develop a skull and has a severely underdeveloped brain. Lauren H. knew that with such a diagnosis, the baby had no chance of survival. Her MFM specialist told her that this condition is incompatible with life. Lauren H. was told that there were many physical and mental risks to her if she continued the pregnancy, including hemorrhage and preterm birth. Lauren H. remembers thinking that she did not want to end up bleeding to death on the bathroom floor. She was scared that when something inevitably went wrong, she would not get proper care for this pregnancy in Texas. She decided that she wanted an abortion. Lauren H.'s MFN specialist said she couldn't help her and was even fearful to give her information about her options. Roe had just been overturned, and everyone Lauren H. countered was terrified. Her MFM urged her to go out of state and tell no one, not her family, not anyone at the airport, where she was going or what she was doing. Lauren H.'s MFM said she could not provide a referral or even transfer her medical records to an abortion provider. No one knew how far the politicians in Texas would go to prosecute people involved in abortion care. Lauren H. and her husband were grieving, were desperate for help, and they were made to feel like everything they needed was illegal. Lauren H. tried to get an appointment with her OBGYN, but he was out of town, and no one from the office was responding. Lauren H. even drove to her OBGYN's office to ask for help in person, but no one would see her. Eventually, someone from the office called back, but only offered her information about support groups for patients who give birth to babies with this condition. Lauren H. realized she was on her own to figure out what to do. Lauren H. called clinics in Colorado and New Mexico. Because Roe had just been overturned and abortion bans were taking effect in states throughout the South, the Colorado and New Mexico clinics were inundated with patients. They didn't have appointments. Lauren H. has struggled with depression, and the stress of searching for care took a huge toll. Her mental health spiraled to the point where she considered checking herself into the hospital, but she was afraid to tell anyone what was going on because she was worried about what would happen to her if people knew she wanted an abortion. Because she was already 18 weeks pregnant, Lauren H. worried that she was too far along to be seen by most clinics. Eventually, Lauren H. got an appointment at a clinic in Seattle that specializes in cases like hers. Lauren H. and her husband's family sent them money to help pay for the extremely expensive last-minute trip. On her way into the clinic for her appointment, protesters shouted at her that she was a baby killer. Lauren H. and her family grieved their loss, but are still processing the trauma of what happened to her and needing to travel so far from home during a time of chaos and confusion just to receive necessary health care. Lauren H. is now pregnant again and due in September. She is both excited and scared because she fears that it's not safe for her or anyone to be pregnant in Texas. Lauren H.'s claims relate both to her current pregnancy and any future pregnancies and are capable of repetition but evading review. Lauren H. sues on her own behalf. Anna Zargarian. Anna Zargarian is 33 years old and lives in Austin, Texas. In September of 2021, just a few weeks after SB 8 took effect, Anna realized her period was 2 weeks late. Anna and her now husband were surprised to learn she was pregnant, but they were excited about having a baby. Anna remembers thinking that it was a good thing she did not want an abortion, as she may have already been past the cutoff for abortion care under SB 8. Anna's pregnancy proceeded without incident until at 19 and a half weeks, she felt a sensation like something was starting to come out of her body. Anna had some cramping but tried to put it out of her mind. Hours later, Anna felt liquid leave her body. Then a second gush left a puddle on the floor. Anna knew something was wrong. Anna and her husband went to the emergency room that night and learned that her water had broken prematurely and her cervix had started dilating. She was diagnosed with PPROM. Anna was told that because all the amniotic fluid had drained when her water broke, her baby would not survive to birth. Doctors in the emergency room told Anna that for patients in her situation, they would usually recommend termination of the pregnancy. If she continued the pregnancy, she was at high risk of developing a septic infection or hemorrhaging. Anna works in healthcare, and as soon as she heard that she was at risk of sepsis, she panicked. The doctors told her the safest treatment for her was a D&E, but because of SB 8, as long as her baby had detectable cardiac activity, Texas law barred them from performing an abortion unless and until her life was in imminent danger. Anna tried to reason with the doctors in the emergency room. She asked if instead of the DNA, they could induce her, but the doctors explained that an induction at this stage was also an abortion prohibited by law. When Anna asked for guidance, the medical staff at the hospital were scared to give Anna any information about where to seek abortion care. Instead, one of the doctors typed a generic abortion finder resource into her cell phone and showed the web page to Anna. Anna was told that she could be admitted to the hospital for expectant management, where she could wait either to go into labor naturally or for her health to deteriorate sufficiently for the hospital to be able to intervene. She was also told that she could wait until the morning to speak with an MFM specialist, but that the MFM would not be able to offer any different treatment. Anna and her husband decided to go home so they could begin researching abortion options on their own. They debated what seemed less risky, an 11-hour drive to New Mexico or a 2-hour flight to Colorado. Anna wanted to make sure the state she chose did not have a mandatory waiting period that would delay her care further. That night, Anna continued to leak amniotic fluid and experienced cramping. The next morning, Anna spoke to her longtime OBGYN. Anna was concerned that if she went into labor while driving through rural Texas, there would be no hospital where she could access care. While she might go into labor or septic shock on the plane as well, at least the trip would be shorter and she could get to a doctor more quickly. Anna and her OBGYN agreed the best option given the circumstances was for Anna was to leave Texas for an abortion and that a short flight was less risky than a long drive. Anna called clinics in Colorado, but they were still being inundated by the influx of patients from Texas. A clinic in Denver was able to squeeze her in once she explained why she would not be able to wait weeks for an appointment. Anna bought a plane ticket and paid extra for a seat at the front of the plane near the bathroom. Thankfully, Anna arrived safely. The morning of her procedure, Anna had a fever of 101, but she received an abortion and recovered well. Since this experience, Anna has suffered from stress and anxiety, specifically related to the fear for her life she felt during the trip to Denver. She grieves the loss of a wanted pregnancy and still relives the trauma of being forced to leave Texas in the middle of a medical emergency. Anna still wants to have children, but she's afraid of being pregnant again in Texas. Her doctors have told her she will be at high risk for developing conditions associated with PPROM in future pregnancies. Anna's claims are capable of repetition, but evading review. Anna sues on her own behalf. Ashley Brandt. Ashley Brandt is 31 years old and recently moved from Houston to Dallas, Texas. Ashley and her husband got married in 2018 and already have a 3-year-old child. Ashley also wanted to have 3 children, so when she learned in May of 2022 she was pregnant with twins, Ashley and her husband were thrilled. During early prenatal visits, Ashley was told she was having identical twin girls and that each had their own placenta and amniotic sac. Ashley and her husband loved being parents and were excited about having twins. They began to tell their friends and family. At her 12-week ultrasound, however, Ashley was told that twin A's skull was much smaller than twin B's, and twin A did not appear to be developing normally. Ashley's OBGYN explained that twin A likely had acrania, a condition where the fetus does not develop a skull, and referred her to an MFM specialist for further testing. For over a week, Ashley waited for her insurance to approve a visit with the MFM. She spent much of the week crying in bed, still reeling from the news and without guidance from her Texas physicians. Ashley started researching her options online and calling doctors in other states. A doctor in Colorado explained selective fetal reduction, and Ashley realized that an abortion of twin A could help her save twin B and herself. Finally, at the appointment, Ashley's Texas MFM confirmed that twin A's skull was not properly developing and that the acrania had progressed to exencephaly, a precursor to anencephaly. The FMM warned Ashley that as long as twin A continued growing, her chances of miscarriage or premature labor were high. Twin A's amniotic fluid would continue to break down the brain tissue until she went into labor, at which point she could lose both babies. Twin B might survive if born prematurely, but would require intensive neonatal care for months or longer. Further, if twin A continued growing, there was a risk of polyhydramnios or excessive accumulation of amniotic fluid, which put twin B at risk for fetal growth restriction. Ashley did not want one stillborn, but she definitely did not want 2. There were significant risks for Ashley as well, particularly because she had a cesarean delivery with her first pregnancy. Ashley learned that polyhydramnios can lead to PPRM and or placenta abruption, meaning that Ashley was at risk for infection, bleeding, and hemorrhage. These risks were especially high because twin A was the twin closest to her cervix. Ashley asked her MFM for selective fetal reduction. Her MFM said that in another world it would be simple, but this was Texas. And in Texas, abortion is illegal, even if it means saving the life of a healthy baby. If Ashley wanted to go out of state for an abortion, that was her right, and her MFM would send her medical records. But in Texas, all her physicians could do was monitor her at weekly appointments. Ashley was on her own. Ashley made an appointment with a doctor in Colorado. Ashley and her husband arranged for childcare, took time off of work, and made the journey to Colorado. Her abortion procedure went smoothly, and Ashley and her husband flew home. The day she returned home, however, twin A's amniotic sac ruptured in the middle of the night, and the bleeding and leaking fluid sent her to the emergency room. She was terrified that she would lose both babies and that she would somehow be in trouble for going out of state for the fetal reduction procedure. Thankfully, twin B had a separate amniotic sac, which was still intact. In the emergency room, Ashley felt a distinct uneasiness and confusion. It appeared the medical staff thought they were not supposed to know about Ashley's abortion or discuss it with her. To Ashley, everything felt secretive and icky. The remainder of Ashley's pregnancy was plagued by fear and stress. Ashley's physicians recommended pelvic rest until her third trimester, as well as weekly ultrasounds that she had to pay for out of pocket. Ashley and her husband kept extra money in savings in case they had to leave the state again for medical care. When Ashley reviewed her medical records, she saw a noticeable absence of documentation of her abortion. Her MFM records contained no reference to their conversations about fetal reduction, and at her appointment after the abortion stated simply SAB of twin A, meaning spontaneous abortion. At every one of her regular appointments with her OBGYN following the abortion, her OBGYN's records listed her diagnosis as vanishing twin syndrome. Footnote 3. Vanishing twin syndrome is a type of miscarriage where one fetus in a multi-fetal pregnancy stops growing spontaneously and is absorbed into either the body of the pregnant person or one of the other fetuses. It was not until she was a few weeks from her due date that her OBGYN added the following note to her chart. One twin with archania was electively terminated. At 38 weeks, Ashley gave birth to a healthy baby. Ashley feels fortunate that she could leave Texas for an abortion and thankful for the support of family and friends. While she had always planned to have more children, Texas's abortion bans make it hard for her to imagine getting pregnant again. Ashley's claims are capable of repetition but evading review. Ashley sues on her own behalf. Dr. Damla Carson. Plaintiff Damla Carson is a board-certified OBGYN in private practice at Comprehensive Women's Healthcare in Houston, Texas, who's licensed to practice medicine in the state of Texas. Dr. Carson has practiced obstetrics and gynecology in Houston since 2001. As part of her practice, Dr. Carson provides gynecological care, prenatal care, and obstetric care for her patients and to her colleagues as patients when she is on call at the hospital where she has admitting privileges. She's also trained to provide abortion care, and before SB 8, she routinely provided abortions to her patients as part of their comprehensive reproductive health care needs. Footnote 4. Before SB 8, Texas law generally permitted physicians to provide a limited number of abortions per year, up to 18 weeks, LMP in their private practices, and up to 22 weeks LMP in a hospital or ambulatory surgical center. Over her career, Dr. Carson has personally treated pregnant patients with a wide variety of obstetrical and other health complications that develop during pregnancy, including but not limited to miscarriage, ectopic pregnancy, management of fetal demise, complications of pregnancy, including cervical insufficiency, PPROM, bleeding, preeclampsia, hyperemesis gravidarum, maternal comorbidities such as hypertension, diabetes, heart disease, kidney disease, cancer, rheumatological disorders, psychiatrical conditions, including those that may lead to suicide, complicated twin pregnancies, lethal fetal anomalies, various genetic diagnosis, including trisomy 13, 18, and 21, structural fetal abnormalities, and molar pregnancy. Dr. Carson consults with specialists in the care of such patients, including but not limited to emergency medicine, hospitalists, cardiologists, oncologists, anesthesiologists, and maternal fetal medicine doctors, and actively participates in the care of her patients who are treated for emergent health conditions during her pregnancies. Dr. Carson intends to continue providing the full scope of care to her pregnant patients in the future. Since SB 8 took effect, Dr. Carson has seen the devastating impact of Texas's abortion bans on her practice and on that of her colleagues. In Dr. Carson's experience, widespread fear and confusion regarding the scope of Texas's abortion bans has chilled the provision of necessary obstetric care, including abortion care. Dr. Carson and her colleagues fear that prosecutors and politicians will target them personally and threaten the state funding of hospitals where they work if they provide abortion care to pregnant people with emergent medical conditions. Dr. Carson has seen that physicians in Texas are even afraid to speak out publicly about this issue for fear of retaliation. Dr. Carson feels she is only able to speak out publicly because she's in private practice and not directly employed by a state-funded hospital. Dr. Carson has also personally treated pregnant patients with emergent medical conditions since SB 8 took effect and consulted with colleagues about the care of such patients. In Dr. Carson's experience, an emergent condition or emergency situation cannot be formulatically defined and will always depend on the patient's unique situation. Since Roe v. Wade was overturned, Dr. Carson has treated patients with emergent medical conditions, including patients carrying pregnancies with lethal fetal conditions who needed treatment for complications like kidney stones, bipolar disorder, and hemorrhage. Before SB 8, Dr. Carson would have offered abortion care to these patients. Now Dr. Carson instead has had to give them information about where to seek abortion care out of state. Dr. Carson sues on her own behalf and on behalf of her patients. Dr. Judy Levison. Plaintiff Judy Levison is a board-certified OBGYN licensed to practice medicine in the state of Texas. Dr. Levison is also a professor in the Department of Obstetrics and Gynecology at Baylor College of Medicine in Houston, Texas. During her career, Dr. Levison had worked in private practice and in educational settings in Washington, California, and Texas, providing obstetrical and gynecological care, including abortion, as well as teaching medical students, residents, and fellows. For the last 23 years, Dr. Levison had practiced obstetrics and gynecology in Houston and taught at Baylor College of Medicine, developing internationally recognized expertise in the treatment of pregnant people with HIV. Over her career, Dr. Levison has personally treated pregnant patients and consulted with relevant specialists regarding many different emergent conditions that arise during pregnancy, including but not limited to miscarriage, management of fetal demise, ectopic pregnancy, infections during pregnancy, including as a result of PPROM, bleeding and hemorrhage, comorbidities such as hypertension and diabetes, preeclampsia, hyperemesis gravidarum, heart conditions including pulmonary hypertension and valve replacement, kidney disease, cancer including cervical and breast cancer, rheumatological problems like lupus or this syndrome, psychological conditions, including those that may lead to suicide, and various fetal diagnoses, including trisomy 13, 18, and 21, neurotube defects like this one, and cardiac defects, Potter syndrome, where the baby does not properly develop kidneys, and molar pregnancy. Since SB 8 took effect, Dr. Levison has seen the devastating impact of Texas abortion bans on her practice and on that of her colleagues. Dr. Levison's experienced widespread fear and confusion regarding the scope of Texas's abortion bans has chilled the provision of the standard of practice of obstetric care, including counseling patients about the options for genetic screening for a chromosomal diagnosis or neurotube defects, and options for abortion if a lethal fetal diagnosis was found. Dr. Levison and her colleagues fear that the prosecutors and politicians will target them personally and threaten the state funding of their hospitals if they provide abortion care to pregnant people with emergent medical conditions. Dr. Levison partially retired from the practice of medicine in July of 2022, in part because after the Supreme Court overturned Roe v. Wade, an abortion became nearly completely banned in Texas. She felt she could no longer practice medicine the way that she was trained and consistent with her ethical obligations as a physician. Texas's abortion bans have made it impossible for her to provide comprehensive, high-quality reproductive care for her patients. While she is partially retired, Dr. Levison still sees patients and regularly consults with colleagues regarding a wide array of pregnancy complications necessitating abortion care, including various specialties. specialists. She regularly consults with OBGYN and MFM colleagues regarding the care of pregnant patients under Texas's abortion bans. Specifically, since SB 8 went into effect, Dr. Levison had consulted with and assisted colleagues regarding patient cases that arguably fall under the emergent medical condition exception, including patients with PPROM, cancer, diabetes, hypertension, suicidal ideation, and who need fetal reduction procedures. Dr. Levison plans to continue to consult with her colleagues on these cases in the future. Dr. Levison has seen that physicians in Texas are afraid to speak out publicly about Texas's abortion bans for fear of retaliation. Dr. Levison feels that she is only able to speak out publicly because she is in the process of retiring. Dr. Levison sues on her own behalf and on behalf of her patients. Plaintiffs Dr. Carson and Dr. Levison are collectively referred to throughout this complaint as the physician plaintiffs. Defendants. Defendant, State of Texas, is responsible for the enforcement of Texas laws, including its abortion bans and the emergent medical condition exception. The state of Texas includes private citizens that could potentially enforce SB 8. Defendant Ken Paxton is the Attorney General of Texas. As the Attorney General, he's empowered to institute an action for a civil penalty against physicians licensed in Texas who violate or threaten to violate any provision of the Texas Medical Practice Act, including provisions triggered by a violation of the trigger bans. The Attorney General is additionally empowered to file a civil action against any person who violates the trigger ban, seeking a civil penalty of at least $100,000, plus attorney's fees and costs. Defendant Paxton has threatened that he will strictly enforce the trigger ban. Footnote 5 is citing to an article. Defendant Paxton is sued in his official capacity and may be served with process at this address listed. Defendant Texas Medical Board is a state agency mandated to regulate the practice of medicine by licensed doctors in Texas. TMB must initiate disciplinary actions against licenses who violate any provision of the Texas Medical Practice Act or Chapter 171 of the Texas Health and Safety Code. TMB may impose discipline on a doctor who violates any state law connected with the physician's practice of medicine because such violation constitutes per se unprofessional or dishonorable conduct, making clear that proof of the commission of the act while in the practice of medicine is sufficient for discipline. TMB shall also revoke the license, permit, registration, certificate, or other authority of a physician who violates the trigger ban. TMB may be served with process at this address. Defendant Stephen Brent Carlton is the executive director of the TMB and in capacity serves as the chief executive and administrative officer of TMB. Mr. Carlton is sued in his official capacity and may be served at the following address. Jurisdiction and venue. This action is brought pursuant to Texas Rules of Civil Procedure 680 to 693, Texas Civil Practice and Remedies Code, Chapter 65 in the Common Law of Texas to obtain declaratory and injunctive relief against defendants. This court has jurisdiction over this matter pursuant to Texas Uniform Declaratory Judgment Acts under this section here, along with this section of Texas Code and Article 5 of the Texas Constitution. Further, this court has jurisdiction over plaintiffs' requests for declaratory and injunctive relief against defendants because the UDJA waives sovereign and governmental immunities for challenges to the validity of statutes. The court also has jurisdiction over the defendants sued in their official capacity because the ultra-vires doctrine permits claims brought against state officials for non-discretionary acts authorized by law, and then we're citing Texas law here. Finally, Texas's abortion bans are enforced through civil means, including steep civil penalties and disciplinary sanctions. This court has jurisdiction to render a declaratory judgment regarding a civil enforcement scheme. Although there are also potential criminal penalties for providing a prohibited abortion in Texas. This court has jurisdiction to enter declaratory and injunctive relief because the bans as civil penalties. Additionally, the court has jurisdiction to end declaratory and injunctive relief because criminal enforcement threatens irreparable injury to physicians' vested property interests in their medical licenses and liberty interests in pursuit of their chosen profession. Citing case law here, holding that the district court had jurisdiction to render declaratory judgment regarding municipal criminal ordinances because the ordinances threatened irreparable injury to the plaintiff's property rights. This court also has jurisdiction because of application of the abortion bans as causing pregnant people to face death, sustain physical injury, and endure extreme mental anguish, which is unconstitutional, and threatens irreparable injury to physicians, plaintiffs, and their patients' rights. Venues proper in Travis County because defendants, state of Texas, Paxton, TMB, and Carlton reside or have their principal offices in Travis County. Plaintiff's request for prospective relief is specifically authorized as a request for declaratory judgment under the UDJA. An action for declaratory judgment is neither legal nor equitable, but is sui generis, that is, of its own kind. Without a declaratory judgment, plaintiffs have no meaningful remedy for their state law claims in accordance with Texas Constitution, Article 1, Section 13. Factual allegations. Background. Sub A, abortion is health care. Every major mainstream medical organization, including the American Medical Association, the American College of Obstetrics and Gynecologists, the American College of Emergency Physicians, and the Society for Maternal Fetal Medicine, recognize that abortion is necessary health care. These organizations are all opposed to governmental interference with patient-physician relationships. Such interference is contrary to the appropriate exercise of professional judgment that medical professionals need to exercise to protect patients' well-being. As the experiences of Amanda, Lauren M., Lauren H., Anna, and Ashley demonstrate, abortion bans are paradigmatic examples of such government interference. The AMA recently updated its principles of medical ethics to clarify that in the context of abortions, physicians must have the latitude to act in accord with their best professional judgment and be expressly permitted to perform abortions in keeping with good medical practice. And there is just a citation here to those rules. The AMA also states that, like all healthcare decisions, a decision to terminate a pregnancy should be made privately within the relationship of trust between a patient and a physician, in keeping with the patient's unique values and needs and the physician's best professional judgment. The ACOG, the nation's leading organization of physicians who provide health services unique to people seeking obstetric and gynecologic care, has long maintained that the following policy on abortion, quote, all people should have access to the full spectrum of comprehensive evidence-based health care. Abortion is an essential component of comprehensive evidence-based health care. Again, we're citing policy down below. While state laws each adopt slightly different legal definitions for abortion, the medical definition of abortion is well understood. An abortion is the expulsion from the uterus of an embryo or fetus, as well as the products of conception before viability. In other words, an abortion is a termination or removal from the body of a pregnancy such that the pregnancy will not result in the birth of a living baby. While the medical treatment is generally the same, medical professionals may draw a distinction from a patient's perspective between a spontaneous abortion or miscarriage, where the embryo or fetus has no discernible cardiac activity, and an induced abortion, where the embryo or fetus has cardiac activity. The pregnant person's desire to have a baby or not, however, has no bearing on whether or not an abortion is considered spontaneous or induced. Again, they're citing a medical text. The majority of abortions in the United States are accomplished either through the use of medications, medication abortion, or via an outpatient procedure, procedural abortion. Medication abortions are typically indicated up to 10 weeks and involve the ingestion of 2 medications to terminate the pregnancy, expelling the pregnancy via bleeding akin to heavy period or spontaneous miscarriage. Procedural abortions are possible through pregnancy and involve a two-step process where the medical provider first does a few things here and then evacuates the uterus, and then some combination of that. Dilation is done either the same day or the day before, and the evacuation phase of the procedural abortion typically takes around 5 minutes in the first trimester of pregnancy and 10 to 20 minutes in the second trimester, depending on the patient's response to the procedure and the complexity of the case. And then, just so you know, we're citing the safety and quality of abortion care in the United States, National Academies of Science. The only other medically proven abortion method is induction abortion, where a physician uses medication to induce labor and delivery of a non-viable fetus. Induction of labor accounts for only 2% of second trimester abortions nationally. Induction abortion must be performed in a hospital of similar facility that has the capacity to monitor a patient overnight and provide pain management. Induction abortions can last anywhere from 5 hours to 3 days, are extremely expensive, entail more pain, discomfort, and recovery time for the patient, similar to giving birth, than procedural abortion, and are medically contraindicated for some patients. While some people attempt to stigmatize abortion care by misusing or conflating pregnancy terminology, e.g., villainizing particular methods of abortion or attempting to distinguish elective abortion from miscarriage, mainstream medical professionals understand that patients in any number of circumstances need abortions, and that pregnant people, in consultation with their medical providers, should be able to choose the method of abortion appropriate for their circumstances. Sub B. Some pregnancies pose emergent medical risks to pregnant people's lives and health. All pregnancy care, including abortion, is time sensitive. Medically unnecessary delays in access to abortion care always harm pregnant people, yet pregnancy can lead to any number of urgent and emergent conditions, if not outright medical emergencies, where especially prompt termination of pregnancy is necessary to preserve the life, health, and/or future fertility of the pregnant person. The American Board of Emergency Medicine defines emergent conditions as cases where the patient presents with symptoms of an illness or injury that may progress in severity or result in the complications, with a high probability for morbidity if treatment is not begun quickly. ACOG emphasized that it is impossible to create an inclusive list of conditions that qualify as emergent or emergencies and thus fall under an exception to a state's abortion ban. Moreover, it's dangerous to attempt to create a finite list of conditions to guide the practice of clinicians attempting to navigate their state's abortion restrictions. This is true for many reasons, including the practice of medicine is complex and requires individualization. It cannot be distilled down to a one-page document or list that is generalizable for every situation. No single patient's condition progresses at the same pace. A patient may experience a combination of medical conditions or symptoms that together become life-threatening. Pregnancy often exacerbates conditions or symptoms that are stable in non-pregnant individuals. There is no uniform set of signs or symptoms that constitute an emergency. Patients may be lucid or appear to be in stable condition, but demonstrate deteriorating health. Nonetheless, medical organizations have described broad categories of types of conditions in pregnancy that are emergent. ABEM's model of clinical practice of emergency medicine, the definitive source and guide to the core content found on emergency physicians' board examinations, contains sections on complications of pregnancies, complications of labor, and complications of delivery. The conditions include ectopic pregnancy, conditions that can lead to dangerous bleeding or hemorrhage, including placental issues, severe forms of hypertension, conditions that can lead to dangerous infection, including premature rupture of membranes, and extreme hyperemesis gravidarum, dangerous nausea and vomiting leading to hospitalization. An ectopic pregnancy is a pregnancy where a fertilized egg implants and grows outside the uterine cavity, usually in the fallopian tube. Ectopic pregnancies cannot result in live births and are life-threatening to the pregnant person because the pregnancy can rupture and cause massive internal bleeding. Ectopic pregnancies must be terminated with medication or surgery as soon as possible after diagnosis. And again, we're just citing different medical texts down here. Cesarean scar ectopic pregnancy, where a pregnancy implants in the scar from a previous cesarean delivery, is considered an emergent condition, where, like any other ectopic pregnancy, the recommended treatment is termination of pregnancy. Hemorrhaging during pregnancy is particularly dangerous for patients, and it can lead to organ damage, organ failure, or even death. A variety of pre-existing chronic health conditions and health conditions that develop during pregnancy can become emergent due to the risk of hemorrhage during pregnancy. These conditions include, but are not limited to, placenta previa, where the placenta covers the cervix, placental abruption, when the placenta prematurely detaches from the uterine lining, placenta accreta, where the placenta grows into the uterine wall, uterine fibroids that inhibit the uterus from contracting effectively and stopping bleeding from placental implantation site, and other forms of first and second trimester bleeding. Severe forms of hypertension in pregnancy can also lead to life-threatening conditions. For example, preeclampsia is a complication of pregnancy, which, when severe, can cause seizures, injuries to the pregnant person's liver and kidneys, stroke, and death. HELLP, or hemolysis elevated liver enzymes and low platelets syndrome, is particularly dangerous variant of preeclampsia. For some patients, other forms of hypertension, sometimes called conjunction with other chronic conditions like obesity and diabetes, can increase in severity and cause the same complications seen with severe preeclampsia. Infection of the reproductive organs, which can lead to chorioamnionitis, infection of the placenta in amniotic fluid, or sepsis, where the body's response to infection damages its own tissues. And another risk that can cause a pregnant person's medical condition to become emergent. Premature dilation of the cervix, for example, dramatically increases a pregnant person's risk of infection and can be caused by conditions like incompetent cervix or weak cervical tissue and or PPROM. Before the onset of labor, PPROM has a relatively high incidence, occurring in approximately 2 to 3% of pregnancies in the United States, and is an emergent condition itself due to the high risk of infection it entails. Other medical conditions can become emergent during pregnancy, either because being pregnant causes or exacerbates a chronic condition or increases other health risks, or because treatment of the chronic condition is unsafe while pregnant. For example, certain cancers requiring radiation, chemotherapy, or major surgery, certain cardiac, autoimmune, respiratory, or endocrine diseases, certain cases of hyperemesis, gravidarum, in certain psychiatric conditions like bipolar disorder, major depressive disorder, anxiety disorders, and psychotic disorders can be emergent depending on the circumstances. Intentional acts of violence or accidents, e.g. motor vehicle crashes, firearm violence, intimate partner violence, and substance use disorder can also lead to emergent conditions. Because each patient's circumstances are unique, it is within the purview of the patient's medical provider to determine whether the patient's comorbidities and or other circumstances make abortion part of the patient's recommended course of treatment. Finally, certain fetal conditions or diagnoses can increase the risk to a pregnant person's health, such that when combined with the patient's other problems, her medical provider may determine that an abortion is necessary or recommended to prevent serious jeopardy to the pregnant person's health. For example, neurotube defects, including anencephaly, certain trisomies like trisomy 13 and 18, the presence of an extra chromosome, triploidy, the presence of an extra set of chromosomes, certain gastric and cardiac defects in the fetus, and Potter syndrome, where the fetus does not properly develop kidneys, are examples of conditions where the fetus either will not survive delivery or likely will not survive more than a few hours or days after birth. As in Lauren M's case, cystic hygromas may indicate the presence of one or more of these fetal conditions. Abortion is generally indicated for patients with such pregnancies, as abortion is typically medically safer for the pregnant person than carrying the pregnancy to term and delivering a baby with no meaningful chance of survival. Some fetal conditions present particularly acute risks to pregnant persons. For example, partial molar pregnancy is a condition where the placenta transforms into an invasive cancer. Oh my goodness. Thus creating an emergency for the pregnant person. Muir syndrome is an emergent complication of pregnancy where the pregnant person and fetus both experience severe fluid retention that can lead to both fetal and maternal demise. In the case of multiple pregnancy, twins, triplets, etc., a fetal condition in one or more of the fetuses combined with the pregnant person's other problems can lead to an emergent condition where selective abortion, sometimes called selective fetal reduction or fetal termination of one or more fetus, is necessary to give the pregnant person and remaining fetuses the best chance of survival. The discussion above highlights some of the emergent medical conditions necessitating prompt abortion care, but the list is by no means exhaustive, nor could it be. Mainstream media associations emphasize that physician discretion to diagnose and treat emergent conditions is paramount to patients' health. Thus, where state laws seek to create a statutory exception to its abortion ban to allow abortion care for the purpose of preserving the life and health, including fertility, of the pregnant person, it must recognize that it is within the purview of the medical provider to determine the appropriate course of treatment for the patient. When a physician determines that such treatment includes abortion, the physician must be able to provide the treatment without concern that a prosecutor, jury, or disciplinary board second-guessing their medical judgment will send them to prison and or revoke their medical license. The nature of abortion is critical health care, and all the more acute in Texas, where maternal mortality and morbidity rates are rising. Texas's maternal mortality and morbidity Review Committee and the Department of State Health Services recently released their joint biennial report, and the results are shocking and alarming. Among the documented pregnancy-related deaths in Texas, a staggering 90% were preventable. According to the report, the maternal mortality ratio for Texas is higher than the national average, 20.2 maternal deaths per 100,000 live births. In 2017, the latest year with available data, compared to the national average of 17.4 deaths per 100,000 live births. In 2018, the closest year for which data is available. The report finds the leading cause of pregnancy-related deaths in Texas was obstetric hemorrhage, and the leading underlying causes of hemorrhage were ruptured ectopic pregnancy, uterine rupture, placental abruption, and placenta accreta, all conditions which are considered emergent. In 2019, at least 13 women in Texas died from a ruptured ectopic pregnancy. The report shows that severe maternal morbidity, defined as unexpected outcomes of labor and delivery that result in significant short or long-term consequences to a woman's health, that if left untreated could result in death, increased significantly between 2018 to 2020, surging from 58.2 to 72.7 cases per 10,000 delivery hospitalizations. The total rate of pregnancy-related illnesses and injuries is likely much higher, as the SMM rate only captures the most severe events, life-threatening conditions, or life-saving medical procedures that occur in specific contexts in hospitals when a patient delivers. Between 2017 and 2020, SMM rates related to sepsis doubled, and SMM rates related to preeclampsia rose by 37% over the same time period. The report also finds significant demographic and geographic disparities in maternal mortality and morbidity, particularly among non-Hispanic Black women, who are twice as likely as white women and 4 times as likely as Hispanic women to die from pregnancy-related causes. Racial and ethnic disparities in pregnancy-related health outcomes are well documented throughout the medical literature. Research has shown that, as compared to non-Hispanic white women, Black women in the U.S. are considerably more likely to experience obstetric complications like hypertensive disorders and preterm birth, and to die from complications like preeclampsia, eclampsia, obstetric embolism, hemorrhage, and postpartum cardiomyopathy. Additionally, Black people in the United States are more likely to have pre-existing conditions that may be exacerbated by pregnancy, such as high blood pressure, asthma, diabetes, sickle cell disease, and lupus. The Texas Maternal Mortality Report further notes that delay in referring or access to treatment, lack of standardized policies, procedures, failure to screen, inadequate assessment of risk, lack of continuity of care, and lack of access financial resources are all contributing factors in maternal deaths in Texas. And we have footnote 30 here. In fact, a report by March of Dimes found that 49.2% of Texas counties are maternity care deserts, where maternity health services are entirely absent. It also found that an additional 22.8% of Texas counties have only low or moderate access, where there are few hospitals or birth centers, few obstetric care providers, or a high proportion of women without insurance coverage. Barriers such as these disproportionately impact Black patients. Black patients face significant barriers to quality, equitable health care, including delays in care, systemic discrimination, and implicit bias in their interactions with healthcare providers. And we have footnote 31, where we are citing here disparities in timelines of care for us when it comes to Medicare patients diagnosed with cancer and various other medical concerns. Black women in Texas also face disproportionate poverty. 19.5% of Black Texans live in poverty compared to 10.5% of white Texans. And 15.5% of Texas women live in poverty compared to 13% of Texas men. This, coupled with Texas's restrictive Medicaid and insurance coverage policies, renders health care unaffordable for many. The Texas Maternal Mortality Report ends with multiple recommendations that are at odds with the demonstrated impact of Texas's abortion bans. For example, promote patient-centered care through shared decision-making, recognizing women as experts in their values and preferences, and supporting informed, collaborative approaches to making healthcare decisions. Support healthcare systems with implementing evidence-based standards, guidelines, and practices, increasing patient and family engagement, promoting healthcare quality improvement, and reducing maternal health disparities. Support emergency and maternal health service coordination as emergency health providers. Knowledge about maternal health, as well as communication and coordination with obstetric and women's health professionals, are critical factors in preventing pregnancy-related deaths. Texas's abortion bans. Texas has several abortion bans relevant to Amanda, Lauren M., Lauren H., Anna, Ashley, and the physician plaintiffs and their patients. Number 1, Texas's definition of abortion. Texas law does not define abortion using the medical definition. Rather, Texas law states abortion means the act of using or prescribing an instrument, a drug, a medicine, or any other substance, device, or means with the intent to cause the death of an unborn child of a woman known to be pregnant. The term does not include birth control devices or oral contraceptives. An act is not an abortion if the act is done with the intent to save the life or preserve the health of the unborn child, remove a dead unborn child whose death was caused by a spontaneous abortion, or remove an ectopic pregnancy. Texas law defines ectopic pregnancy as the implantation of a fertilized egg or embryo outside of the uterus. While there is no express definition, it's generally understood that in the context of Texas's definition of abortion, dead means there's no cardiac activity present in the embryo or fetus, emphasizing importance of a fetal heartbeat or cardiac activity to unborn life. Abortions done to save the life or preserve the health of an unborn child are not considered abortions under Texas law. Applying exception to abortion ban where the person performs, induces, or attempts the abortion in a manner that, in the exercise of reasonable medical judgment, provides the best opportunity for the unborn child to survive, unless, in the reasonable medical judgment, the manner would create a serious risk of substantial impairment of a major bodily function of the pregnant female. Texas abortion bans cite back to Texas's definition of abortion, meaning that neither medical care involving removal of an ectopic pregnancy nor removal of pregnancy tissue where no cardiac activity is present is an abortion under Texas law. Trigger ban. Texas criminal ban on abortion is often referred to as the trigger ban because, while signed into law in 2021, it's specified a contingent effect date and did not take effect until August 25th of 2022, 30 days after the Supreme Court issued its judgment overturning Roe v. Wade. The trigger ban states a person may not knowingly perform, induce, attempt an abortion, citing Texas's long-standing definition of abortion. There are both criminal and civil penalties for violations of the trigger ban. A person can be charged with either first or second degree felony for violating the trigger ban. First degree felonies are subject to imprisonment for life or a term between 5 and 99 years. Second degree felonies are punishable by imprisonment for a term of between 2 and 20 years. Further, the trigger ban states that the relevant licensing authority, the Texas Medical Board, shall revoke the license, permit, registration, certificate, or other authority of a physician or other healthcare professional who performs, induces, or attempts an abortion in violation of the trigger ban. Finally, any person who violates the trigger ban is subject to a civil penalty of not less than $100,000 for each violation, and the Attorney General shall file an action to recover a civil penalty assessed under this section and may recover attorney's fees and costs incurred by bringing this action. The only exception to the trigger ban is an abortion performed by a physician on a patient with an emergent medical condition. Senate Bill 8 of 2021 prohibits physicians from providing an abortion in Texas if the embryo or fetus has a detectable cardiac activity. SB 8 took effect on September of 2021 and creates additional civil penalties for physicians who perform abortions prohibited by SB 8. Violations of SB 8 are subject to a bounty hunting civil enforcement scheme, allowing any individual to seek statutory damages in an amount of not less than $10,000 for each abortion that the defendant performed, and injunctive relief sufficient to prevent the defendant from violating SB 8 in the future. Like the trigger ban, the only exception to SB 8's ban on abortion is pregnancies with the detectable cardiac activity is an abortion performed by a physician on a patient with an emergent medical condition, discussed in detail below. SB 8 also created new state documentation and reporting requirements that apply to all abortions performed under the emergent medical condition exception. As of September 1st of 2021, all abortions performed under the emergent medical condition exception must be documented in detail by the treating physician. Specifically, the physician must execute a written document, 1, that certifies the abortion is necessary due to a medical emergency, 2, that specifies the medical condition the abortion is asserted to address, 3, that provides the medical rationale for the physician's conclusion that the abortion is necessary to address the medical condition, 4, place the document in the pregnant woman's medical record, 5, maintain a copy of the document in the physician's practice records. SB 8 also requires physicians who perform abortions at abortion facilities to report all abortions performed under the emergent medical condition exception to the state. requiring reporting to include whether the abortion was performed or induced because of a medical emergency and any medical condition of the pregnant woman that required the abortion. Pre-Roe ban. The Texas abortion ban at issue in Roe v. Wade also contained an exception for the life of pregnant persons. After the pre-Roe ban was held unconstitutional in 1973, it was removed from the Texas Penal Code and Texas Civil Code. The Texas legislature then enacted a comprehensive statutory scheme permitting and regulating abortion. In light of those later enactments, the Fifth Circuit held that pre-Roe ban was impliedly repealed. On June 24th of 2022, for the first time in the text of pre-Roe ban was placed on the Texas legislature's website with the note that the relevant statutes were held to have been impliedly repealed in McCorvey v. Hill. Despite that holding and subsequent litigation regarding pre-Roe ban, defendant Paxton took the position that the pre-Roe ban was immediately enforceable after Roe v. Wade was overturned. Courts addressing this issue after Roe was overturned, however, largely disagree. The court finds the pre-Roe laws have been repealed by implications. Here, treating the pre-Roe ban as enforceable, but nothing that the trigger ban reflects a more recent, more specific regulation of abortion, and normally a more recent enactment governing the same subject supersedes prior enactments. Exception to Texas's abortion bans for emergent medical conditions. Texas's abortion laws have long recognized that providing abortion care to pregnant people with emergent medical conditions is exempted from the state's various restrictions on the provisions of abortion. Yet, inconsistencies in the language of these provisions, the use of non-medical terminology, and sloppy legislative drafting have resulted in understandable confusion throughout the medical profession regarding the scope of the exception. History of the emergent medical condition exception. Texas's emergent medical condition exception first appeared in the Texas Code in 2011 when Texas updated its informed consent requirements for abortion and created exceptions for cases of so-called medical emergency. It defined medical emergency as a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that, as a certified physician, places a woman in danger of death or serious risk of substantial impairment of a major bodily function unless abortion is performed. Over the last 10 years, Texas has added numerous requirements to its abortion code utilizing this definition, having exceptions for medical emergencies. For example, in 2017, Texas passed a ban on dismemberment abortion, essentially a ban on dilation and evacuation abortions that has an exception for medical emergencies. SB 8 is another example. The only exception to SB 8's abortion ban is its associated civil penalties is for patients where a physician believes a medical emergency exists. The same language in the definition provision appears as the sole exception to the trigger ban. Specifically, Texas's criminal ban on abortion does not apply if 1, the person performing, inducing, or attempting the abortion is a licensed physician, 2, in the exercise of reasonable medical judgment, the pregnant female on whom the abortion is performed, induced, or attempted has a life-threatening physical condition aggravated by, caused by, or arising from the pregnancy that places the female at risk of death or poses a serious risk of substantial impairment of a major bodily function unless the abortion is performed or induced, and 3, the person performs, induces, or attempts the abortion in a manner that, if in the exercise of a reasonable medical judgment, provides the best opportunity for the unborn child to survive, unless in the reasonable medical judgment that manner would create a greater risk to the pregnant female's death or a serious risk of substantial impairment of a major bodily function of the pregnant female. 2, physician discretion under the emergent medical condition exception. Courts have long recognized that where an abortion ban provides an exception for patients in certain circumstances, a good faith standard rather than a reasonable person standard must apply. Citing case law here, and I will skip through that case law. The emergent medical condition exceptions language, which appears 5 times in the Texas Abortion Code, contains conflicting language across the different sections regarding physician discretion and intent. This leaves physicians uncertain whether the treatment decisions they make in good faith based on their medical judgment will be respected or will be later disputed. For example, the trigger ban defines reasonable medical judgment as a medical judgment made by a reasonably prudent physician, knowledgeable about a case and the treatment possibilities for the medical conditions involved. Yet the trigger ban also prohibits a physician from knowingly providing a prohibited abortion. Thus, a physician does not violate the trigger ban by providing an abortion in reliance to the exception unless the physician subjectively knows that in the exercise of reasonable medical judgment, the patient does not have a condition qualifying for the exception. When a physician relies on the exception in good faith, the physician does not know that the exception does not apply. Stated differently, a physician cannot knowingly violate the ban if she acts in good faith reliance on the exception. Meanwhile, the definition provisions language which applies to SB 8 does not explicitly mention intent. Instead, the language as certified by physician modifies the exception language, suggesting that the treating physician's good faith certification buttressed by the documentation and reporting requirements for the medical emergencies added to the code by SB 8 governs the assessment of patient's circumstances. Physicians confronted with the question of whether or not a patient qualifies for the emergent medical condition exception must consider not only their ethical responsibilities as physicians and potential medical malpractice liability if they do not follow the standard of care, but the risk of loss in liberty and loss of liberty in prison sentence they will face, and the potential loss of their license to practice medicine and pursue their chosen profession if they are found guilty of violating an abortion ban. Understandable confusion regarding physicians' levels of discretion under Texas abortion bans and fear of the legal consequences if they are wrong is leading to physicians denying care to patients, including patients presenting with emergent conditions, even when such care likely would fall within the exception. As plaintiffs' experiences show, because the law's uncertainty, physicians are over-complying with the laws to the detriment of their patients' lives and health. Texas has failed to provide clarification or guidance on the meaning of the exception, despite being asked repeatedly. Texas's abortion bans can and should be read to ensure that physicians have wide discretion to determine the appropriate course of treatment, including abortion care for their patients who present with emergent medical conditions, without being second-guessed by the Attorney General, the Texas Medical Board, a prosecutor, or a jury. Next, conditions included in the emergent medical condition exception. So at this point, everybody, I am going to start to summarize a little bit. We are 90 minutes into my live. That's usually as much voice as I can do. So let me summarize this next piece here, and we'll kind of catapult to the end. So conditions included in the emergent medical condition exception here, they're saying the terminology that's being used in the law is not the same as medical terminology, which is leading to a lot of confusion. Terms like life-threatening, major bodily function, those kinds of terms. So we have a clear issue between medical and legal jargon here. So they're going again into further questions on what the different terminology means. Number 4, legislative intent regarding the scope of the emergent medical condition exception. So here the intent, while sparse, is instructive. So here we've got, they go into the primary sponsor, and so not whether or not the woman has a physical condition that meets the requirements is one of the pieces. So they're looking at what did they actually intend by emergent medical condition here. So they go into that legislative history. Again, I am fast forwarding through this here because there's quite a bit left. Number 2, in the absence of state guidance regarding the exception, Texas abortion bans are harming pregnant people with the emergent medical conditions and their physicians. So Here, they're going first into the impact of Texas's abortion bans on pregnant people, and they're recapping the stories that we started with. So we have Amanda, Lauren M., Lauren H., Anna, and Ashley here. And then they're stating there are a lot of other people, but they're sharing their stories anonymously. Another story is Christina Crookshanks, Elizabeth Weller, Kaylee Despain, a League City resident, again, who was only able to go anonymously here, and then other anonymous people as well, people who have passed away because they had been denied care. The stories are not unique to Texas. Ever since Roe v. Wade was overturned, lots of states with similar bans have had similar issues. So Madison Underwood here is from Tennessee. Allie Phillips from Tennessee is having issues as well. Sarah from Tennessee. Caitlin Joshua from Louisiana. Nancy Davis, a Louisiana resident. Christine Zeckel, who is visiting Ohio. Tara George, an Ohio resident. Again, I'm not trying to diminish the stories of these women, but I am just going to kind of fast forward a little bit through here. Beth Long, who is an Ohio resident, and if you are wanting the details of these women's stories, you can, of course, pull this case and read through each one individually. We've got Carmen Brosder, who was an Idaho resident, Alyssa Gonzalez from Alabama, Jill Harder from South Carolina. And these stories are heartbreaking. Melissa Farmer from Missouri, R from Missouri, Deborah Dorbit from Florida, Annabelle Lopez from Florida, Amy English from Kentucky, Leah Martin from Kentucky, and then additional stories again of other women who have either been permanently damaged, harmed, or have died because of the bans put into place in other states. Again, you can go through and read those stories if you're interested. B, confusion and fear throughout the medical community regarding Texas's abortion bans and similar bans around the country. Again, they're going into the problem of this medical language versus the legal language and the problems between that and how they're defining it. Life-threatening treatment, medical condition, what do those mean? Also, the liability, medical malpractice is a huge issue throughout everything, and now they're adding another element to it here. Fear of liability under the abortion bans is so great that some physicians even have changed their standard treatment methods. So they're changing how they're treating women, pregnant people, because they are afraid of being sued. Again, severe restrictions have eliminated some of the options that a doctor can give to their patients. Talking here, we've got Dallas hospitals in particular that they're going into. They've got different management programs that they're trying in order to figure out how the law actually works. The restrictions on SB 8 erode the patient-physician relationship, evoking fear and safety concerns and creating a significant burden on patients to understand pregnancy options. So that's another piece of it. Again, going into some of the more significant complications like PPROM and how they're supposed to deal with those kinds of complications when they're not sure whether or not they can perform the medically needed surgery or procedure. And then that takes us to 3. The Texas Constitution protects pregnant people from emergent medical conditions and their physicians from state deprivations of their rights. So pregnant people have a fundamental and equal right under the Texas Constitution. So we have Equal Protection Clause set out in Article 1, Section 19 of the Texas Constitution. They're claiming under the equal protection provision that pregnant people are included there. Texas licensed physicians have liberty and property rights to provide care to pregnant people with emergent conditions. So this is kind of your right to work. Those rights are being infringed on as well for the physicians. And going back in here, talking about having their licenses removed from them or the kind of stigma that comes from being reprimanded. So that takes us then, everybody, we kind of catapulted here to where I wanted to hit next, which are the claims. So let me walk you through the claims, what they're asking for in this lawsuit, and then we'll wrap up with a Q&A directly afterwards. So let's get into the claims. Claim 1, declaratory judgment. The allegations in paragraph 1 through 292 are above incorporated, fully set forth herein. Plaintiffs hereby petition the court pursuant to UDGJA. Here provides remedial aid. Purpose is to settle and to afford relief from uncertainty and insecurity with respect to rights, status, and other legal relations. And it is to be liberally construed and administered. Here, a court of proper jurisdiction has the power to declare rights, status, and other legal relations, whether or not further relief is or could be claimed. The declaration may be either affirmative or negative in the form and effect of declaration on the force and the effect of the final judgment. Here, the plaintiffs are seeking declaratory judgment. Again, this is in front of the Texas Supreme Court this week. And what they're asking is they're saying we're permitting physicians to provide pregnant persons with abortion care when the physician determines in their good faith judgment and in consultation with the pregnant person that the pregnant person has a physical emergent medical condition that poses a risk of death or risk to their health, including their fertility. So this is what they're asking for. They're specifically focusing on these emergent medical conditions. They're wanting that language changed and the declaratory injunction put into place. Next, we've got the allegations here again are incorporated through this. Any official's enforcement of Texas's abortion bans against any physician who provides an abortion to a pregnant person after determining that the physician's medical judgment pregnant person has a physical emergent medical condition for which the abortion would prevent or alleviate a risk of death or risk to health, including their fertility, would be inconsistent with the emergent medical condition exception to Texas's abortion bans and therefore would be ultra vires. Plaintiffs have sued the defendant state officials in their official capacities, seek prospective relief other than recovery of monetary damages. Therefore, government immunity does not apply. Again, they're asking for injunctive relief. Section 19, rights of pregnant people. Again, they're going in and they're saying, hey, we're seeking declaratory judgment under Article 1, Section 19 of the Texas Constitution, which guarantees a pregnant person a right to an abortion where the pregnant person has an emergent medical condition that poses a risk of death or risk to their health, including fertility, which needs to be included, and an abortion would prevent or alleviate such risk. So they're including that language as well. Next, we've got Claim 4, equal rights of pregnant people. This is under their Equal Protection Clause in their own constitution. Claim 5, equality based on sex for pregnant people as well. Now, the extent that the abortion bans or delays the provision of an abortion to a woman known to be pregnant to treat an emergent medical condition that poses a risk of death or risk of health, including fertility, while allowing other people access to medical treatment. Texas abortion bans deny pregnant women equally because of sex. So again, that has to do with how the language was put out in the law. Section 6, Section 19, rights of physicians. Again, the loss of their practice if they're called out for performing medical treatment. Prayers for relief is the very end. So this is what they're asking for. The plaintiff asked the court to enter a judgment against defendants, granting appropriate declaratory relief to clarify the scope of the exception of Texas's abortion bans consistent with the Texas Constitution. To enter a judgment against the defendant, state officials that enforcing Texas's abortion bans, contrary to the court's declaration regarding their scope, would be ultra vires. To enter a judgment that Texas's abortion bans as applied to pregnant people with emergent medical conditions and Texas licensed physicians treating such patients violates the Texas Constitution. So that's the Equal Protection Clause, as well as the rights if you have an emergent medical condition. To issue permanent injunctive relief that restrains defendants, their agents, servants, employees, attorneys, and any persons in active concert or participation with defendants from enforcing Texas's abortion bans or instituting disciplinary actions related to alleged violations of the abortion bans in a manner violating the court's judgment, to retain jurisdiction after judgment for the purposes of issuing further appropriate injunctive relief in the court's if the court's declaratory judgment is violated, and to such other and further relief as the court deems just and proper. So there you have it, everybody. They did attach Exhibit A here if you are interested. And this is, again, a letter going over concerns over allegations received involving potential corporate practice of medicine in patients experiencing pregnancy complications. So there's a letter supporting that. All right, everybody, let me go ahead and get the comments turned back on. Just one moment. Okay, hello everybody. Hello. Sorry, we kind of had to speed through the back end of that, but hello. Here we are. Yes, here we are. Good to see everybody. Hello. It was a very, very well written, incredibly well written. 90% of deaths avoidable. Yes, that's heartbreaking, isn't it? Absolutely heartbreaking. Yeah, it's tough. Thank you for reading. Yes, absolutely. Yes. Again, I did need to kind of truncate the end of it there, but it's an incredibly well-written petition. It's a very well-written petition. I think their legal arguments are very solid. I'm not sure about their constitutional questions, which is really what's being argued in front of the Supreme Court. Equal protection is really the big issue. That was the issue in the Dobbs case. It is sad, Deb. It is. Do I need some tea? Yes, I will I will have a little tea. Oh my goodness. It's absolutely worth your time. Like I said, I did kind of speed through the very end of it. But if you are interested in the personal stories, in the stories of other women in other states outside of Texas, it is worth the time to take a look at those stories. You know, and what's interesting too is that the laws, we just went all the way back in time. We went to pre-Roe. We went to laws that were in place before Roe was decided. So almost overnight, we catapulted all the way back in time, decades after the Dobbs case. Last line of each plaintiff's introduction. Review not. Oh, sure. So let me give you an example. Let me show you here. So, all right. So, oh wait, the doctor one isn't the best example. Hold on here. Let me see. Got Anna here. Let me see. All right. So here's an example. So Anna's claim are capable of repetition but evading review. She sues on her own behalf. Is that what you're talking about? If that's what you're talking about, this is because, we have to have standing in order to bring a lawsuit. And because a lot of these cases, of course, the timing of it is so important, right? So each of these women have already been through their process. One is currently pregnant, although technically I think she's already had her child. But because they're not pregnant, they're saying this is still a relevant issue because it can be repeated. This was the same basis on which the Roe versus Wade case was brought, because they're saying, by the time Roe made it to the Supreme Court, she wasn't pregnant anymore. So the issue was moot. But what they said was because her case was capable of being repeated and unable to make it through court when she was still pregnant, so it's evading review, then there's standing grounds. The Ultra V, that was a situation too where they're saying you shouldn't be able to come back in later and sue the physician for making their medical choice. So it's a punishment being set out for making that medical decision. Let me bump this up a little bit here. As another piece. So multiples, moms. Oh my gosh. Yes. Multiples. Yeah, absolutely. And, that's the thing is when you start mixing the law and medical issues together, that's a problem. I mean, that's where the problem is. Woman once she's declared pregnant. Well, right. I mean, and it's not even the woman. It's the potential for future life. And only that potential. The actual life itself isn't necessarily protected later on either. So it's a big, from the first case. Oh my gosh, I know. It's heartbreaking, everybody. It's absolutely heartbreaking that we have gone back in time because of how they have written the law here and in multiple states, Tennessee, Florida. We have gone back to what it was like before Roe was passed. I mean, that's where we're at. And for whatever reason, somehow with all of the advances that we've had in science and technology, when it comes to this particular medical issue, we have completely gone back in time. Not using proper medical terms exactly. And that's a huge thing. And I think lawmakers, in the way that the people make law, just to kind of clarify that, we have lawmakers who are elected, right? Now, they're not all lawyers. They're not trained in how to write law, and that's fine. They don't have to be. What they do is they say, well, this is what I want to have happen. How do I need to change the legal language to make this happen? So there's usually like an office, a legislative office there filled with attorneys, academic attorneys that will tweak the law and change the language in the law so that the wording fits in with the state code to have the effect that they're wanting it to have. So what I'm thinking has happened here was that legislative office that helped put the words together was working with the people sponsoring the bill, and the language that they wanted to use, the people sponsoring the bill, was so specific because of what they wanted to achieve with the language as opposed to the practical effect of it. The medical terminology was just not put into place properly. I think if the medical terminology had been used, everybody could have gotten what it was they were looking for. But it just didn't happen. Punishment if you get an abortion in a different state. Yes, I saw that in Idaho. Sue your doc. Yeah. And, medical malpractice is a real thing, and rightfully so. But in this particular case, if they're trying to do life-saving treatment, you can still, unfortunately, be sued on that. Challenged by terms and ideas like men know, but exactly. And, somehow they think, one or two words can absolutely make the difference. Like, as you probably noticed in the Texas law, when it was written, referring to a child. Again, it's not a child. That's not the correct scientific term. Child is defined differently. And so because of that, there are all these complications and problems. So again, when the language is not making peace with the medical language, there's just this fundamental battle going on now. So it's not even an ethical or religious question. It's literally a medical terminology issue that could be resolved if there was an agreement on which terms meant what. And I know they had lots of hearings and lots of experts that came in to testify, but they just chose the way that they wanted to go. Unfortunately, and unfortunately for medical issues, it's just not going to work. You can't bulldoze your way through it. It was written without considering how complicated life is. I think that's a good point, Cozy. I think that's a very good point. New laws are changed. Right. And it's so fascinating because there is this, terrible, ideology of, oh, well, just someone goes in, they're like, I just don't want to have a kid. I'm going to go and have an abortion and take care of it, completely terrible information and inaccurate medical information, and this kind of like stigma and thing that people just had stuck in their head, where the doctors and nurses and various people that came in to try to explain, look, that's actually not how it works. Let's explain how it works. But it was falling on deaf ears. What's the step needed to add it to the Constitution? So great question, Kristen. Now, we know in Ohio, they went forward to do that. And in multiple states, they're going forward to do it as well. So it is possible you would need to pass an amendment. The issue with Texas is that they've already tweaked some of the language, but even by tweaking that language, it's still so murky. They're not sure what exactly it means. So they would have to really kind of toss everything and restart with better language if they wanted to put some safety into place for pregnant people. Yeah, and the women have to pay the price. Yeah, yep, they do. They do, yep. Have trouble finding qualified doctors to practice in their states. Very true, Tanya. And very, very, very true. At the federal level, yes. So, Kristen, that's an excellent question. At the federal level, too, of course, we would need to pass a constitutional amendment, or it would need to be put into the federal code. I always use the example of same-sex marriage. That's the example I always use. So we had the Obergefell case that was decided and said you can't discriminate based off of if two people are of the same sex and they're getting married. So you can't do that. Now, there was some controversy with that, and people knew the Supreme Court could overrule themselves later on. So they codified it and they put it into the Marriage Act. They made a federal statute that set out marriage was okay along those grounds. That's what they need to do. They need to make a federal statute. We don't need a constitutional amendment, but a federal statute that sets out federal procedure when it comes to, life-saving medical treatment. That would be really important. Women, trans men, non-binary people. Oh, they all do. Absolutely, Thomas. Any pregnant person whose life is at risk, and anyone who loves a pregnant person whose life is at risk as well. Absolutely. Pregnant people. Maybe you should write it. That's an interesting question, Kristen. That's interesting. Let me make a note. I'm wondering if there is a proposed. There have been a lot of proposed bills over the years, everybody. Just none have passed. I might pull some up and see what they say. I would be interested to see that. You're determined to scrutinize. Well, yeah, exactly. I think our country as a whole had a big wake-up call on what could happen if the Supreme Court gets away from us, I mean, it's really important. It's really important. We need the House and the Senate to codify Roe. Exactly, Carly. You got it. Yeah. Or Carol. So, yeah, they would need to propose the statute federal and make it federal law to protect just the basics. Now, federal law sets the giant guidelines, right? So, like the total amount of air pollution is this giant cap, and how each state goes about defining that, they can make it as restrictive or as loose as they want. They just can't be way out of line with the federal government. So what I'm trying to say is they put the minimum standards in at the federal level, which is what Roe did. Minimum standards, just by saying it's allowable. You can't completely make it illegal. All that would be needed would be a statute stating, again, that it is not allowed to be made illegal at all. You have to have some form of care that allows for it. Now, what it is, each state would need to decide, and each state would regulate that. But the federal law would simply say what the Roe case said, which is that you can't deny it. You have to have some situation where an abortion would be allowed. And, for medical reasons, for the mother, for the child, for whatever reason, there has to be some exception that allows for it. That's what the federal law would do. Love your red nails. Thank you. Thank you very much. Yeah, they were purple earlier today, but they looked a little too peanut butter and jelly. So yes, absolutely. Texas is horrific with their language dismemberment. Oh my gosh, Jan. Yeah, that's totally inappropriate. And I think it just shows some of the state legislatures are just, a little bit bonkers right now. They're kind of running away from what they really need to do and taking such extreme measures. But what is happening is time and time again, as we've seen in Florida multiple times, as we saw in Georgia just recently regarding the special board that they were setting up for prosecutors, the courts are saying, look, people, you can't do that. You can't be doing that kind of stuff. Why haven't they codified it? That's a great question. So right after Roe was passed, it started. It started in Congress. The debate started, the forever debate, trying to codify it. And every single year, the issue was brought up and turned down. We could not come to an agreement. We just couldn't do it. So after decades of trying, the abortion issue had never been resolved. And that was how the Supreme Court, in one fell swoop with overturning Roe in the Dobbs case, were able to do this, because there was no protection through the federal government, through Congress, because they just could not reach an agreement together. Yeah, again, but Lindsay, that's your choice, right? Absolutely. People, that's the thing is, you shouldn't have to be forced into anything. Let alone, that's why the ERA is still working on it, still working on that. What would be the equivalent to prevent you from practicing law as a doctor? What would be an equivalent to prevent you from practicing? So I guess, if there was somehow, that's a great question, Suze. I know that in some place, I'm thinking Florida actually, that there are some laws now where you're unable to sue certain people. So I think when we have a qualified immunity situation, anything like that, or where someone is an exception to being sued, that's when our hands as attorneys get tied. And we're like, wow, we see this huge wrong that's occurring. And in any other situation, we would go forward with your suit. But because of who it is, we can't bring the suit. So that would kind of be the equivalent of where we're saying this should totally happen. And again, if it wasn't a cop, if it wasn't someone in law enforcement, I would be able to take this all the way. But because they're protected by qualified immunity, I can't. Or because there's a cap on how much you can sue for, even though they took the wrong leg during surgery. I'm so sorry. Normally we could sue, but, we can't because there's a cap on it. Different religions define life at different points. Abortion laws are. Well, it seems like it, Daisy. It seems like it. When we get too far removed from the medical terms, from the medical and the science parts, that's when we start to have troubles. How do we combat the ignorance? That's a great question, and I'm not sure. I tell you, I have someone in my world who is a scientist, and sometimes he'll come back and he'll look at me and he's like, did you not know this about science? And I'll be like, I had no idea. I had no idea that this was a thing. And he will just look at me like I've grown a second head. Like, what are you talking about? Like, he can't believe some of the basics that people just don't get when it comes to science, that we're just not taught. So whenever he's writing a question or reviewing something, he'll always ask me, he's like, I need, a layperson's perspective on what this means scientifically. And I'm like, you mean a dumbass? And he's like, that's right. So I'm like, all right. What's the question? So that's kind of how that goes. But he's, it happens. And it happens in my field too. I can do the same for him. Like, let's have a layperson. What does this mean to a layperson? And he's like, I don't know, put the mugshots away. We're eating dinner. So, it's tough. It's hard to kind of get all that information out. Yeah, we help each other. We help each other. Blinded me with science. Yes, it's a problem. Yes. Hey, I know what I know, but I certainly don't know a lot. Oh my goodness. Yes, yes. So I can completely understand though when he's like, I just the basic fundamentals. A lot of people are out there. So, oh, thank you, Steve. That's so sweet of you to say. It happens in all specialties. Absolutely. It absolutely does. And, unfortunately, if I screw something up legally, yeah, I might mess up something and someone might lose money or something may unfortunate happen. But when you screw up the law like this, when you're writing the law and you screw it up this way, people die. I mean, that's like a big problem. That's a big problem. We need to be able to learn from each other. Oh, absolutely, Suze. Absolutely. No, I'm the first person, I will admit, I have huge gaps in my in my knowledge. Like I know a lot of stuff, but I know a lot of stuff that I don't know. Mugshots at the table. Yeah, sometimes my papers get scattered. I saw the other day. I had just finished the live and I had left the mugshot out and he came in and he's like, "Oh my God." Like, sorry. Put the bad man away. I know. He just isn't having it. Oh my gosh. Yeah, he's not having it. Oh my gosh, Sarah. Yeah, the medical terminology. I definitely could use some help on that with that for sure. I do try, but abortion is healthcare. Absolutely, absolutely. I seriously, it really is. I understand. That's so much better than thinking you know more than you actually do. Oh my gosh, Born to Bark. I have huge gaps, huge. But I do know a lot about what I know a lot about. So I feel comfortable about that. But how can we know everything, right, everybody? I mean, something else has gotta give. Like my sense of directions, like I could pull a case up from 1918, but if you tell me which way's left, I'm gonna struggle for a minute. Oh my gosh. Navy vet, I just take pictures. I just take pictures of whatever it is and I just show it to people when it comes to terminology. For sure. Showing it's fixable. Sometimes with computers we're seeing people get, yes, absolutely. You learn something new every day. I hope so. I learn every single time I come on a live. I learn something new. I learned something from all of you and I'm so thankful for it. For sure. So, but it's a huge issue, everybody. This is a huge case. I really hope the Texas Supreme Court gives it the time and appreciation that it needs. So, guidance and teachers involved. Oh, I'm so glad. I'm glad. Yes, really bad morning sickness. Yeah, exactly. And oh my gosh, that's awful because what can you take for it when you're pregnant? You have to be so careful. I mean, it's just, I can't. Oh, it's awful. Awful. It's very, very hard. It's difficult. It's absolutely difficult. So left is right, right is left. Yes, I could, I could, it's all right. Oh, it's all right. As long as you can remember the Civil War cases, you're fine. We have people on IV medication for months for that. Oh, absolutely. And I think too, sometimes, I'm not sure if it's the media or what, but I think people sometimes forget how hard pregnancy is. I mean, that's huge. That's like a major medical situation going on for months and months. I mean, that's a lot. Do you think this will go to the Supreme Court again after the ruling? Yes, I do, Mads. I do think it'll go to the Supreme Court again. And I think the Supreme Court needs to get itself sorted out. Absolutely, it'll go back up. Now, this particular case, because this is a Texas case and it's Texas law, I do not necessarily see this making the jump all the way to the U.S. Supreme Court because of this, specifically because this is a medical exception question. But there are other cases in other states that could make it up to the U.S. Supreme Court. It's possible. Would the Supreme Court just rule the same way? I don't know, Daniel. I don't know. Dobbs, I think, was very close. I think there were a lot of things at play with the Dobbs decision. And I think a lot of things have been learned since Dobbs. So at this point, I'm not sure, honestly, to be completely honest, I'm not sure. I truly do not know that Gorsuch and Kavanaugh would rule the same way again. I really just don't know. I really don't. It's possible, but it's also possible they could go a different way depending on how it is, depending on the kind of case. So we'll see. We'll see what happens, everybody. But truly, the best way to go about it is to get something passed through Congress. That is really what we needed. And I think the Supreme Court really showed that to everybody. Like, hey, you guys are playing around long enough. Now we're done. So we will see what happens. Oh, my moderators are gangster every night. We love them. Oh, legislating. Yes. And medical situations. Come on, right? Impossible not to see how unpopular their ruling was. Oh my gosh, Mads, I think this was a wake up for them as well. I cannot say for a moment that the Supreme Court has not acknowledged the effect that the Dobbs case has had. Now, whether or not it's affected them the same way that it's affected the rest of us, who knows? But I have no doubt that they acknowledge how historical that situation was. Absolutely. So I'm not sure what will happen. All right, everyone, let me grab my calendar here real quick. I don't have the mug shots. I had to put the mug shots away. Thank you for covering. Oh, yes, absolutely. No, Sarah, I'm glad you brought it up. I think I've been looking through Mr. Thug's RICO, and I think it's very interesting to kind of compare and contrast Trump's RICO case and Mr. Thug's. Now, he's got a lot more triggering words because there are homicides and drug deals and all kinds of crazy stuff involved. So it's a bit manic, but only in the best way. I think it'll be very interesting to kind of, again, compare and contrast between the two cases. So we will be going through Mr. Thug's RICO indictment tomorrow. He has been charged, him and multiple other people. We've got, I think, 80 counts maybe, I think, total. So I'll walk you through his case. It's a lot. It's a lot, everybody. But Miss Fani is taking care of that case as well. She's been working on it for a couple of years now, actually. There's some great pieces of it that she has really taken over. So Mr. Thug, yeah, I think, what's his name? Like Young Thug, I think is his name. I think that's his name. I just call him Mr. Thug. I don't know. Everybody's a Mr. to me. If you're a defendant, you're a Mr. Mr. Thug. Well, it could be. But we will go through his RICO indictment tomorrow then, everybody. So, yeah, he's a rapper, Mr. Thug. We'll go through that tomorrow. So, all right, everybody, best to sign off now. It's been great seeing you all, as always. Oh, my goodness. I will be back again tomorrow, everyone. Have an amazing night. I know this was a heavy read tonight, so, but so important to share. So have a great night, everybody. I'll be back again tomorrow. Thank you, as always, moderators, for all of your hard work, and thank you, everyone, for coming and hanging out. So take care, everyone. I will be back tomorrow. Oh, my goodness. I'll be back tomorrow. Have a great night.